Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, with the labor attorney Jung Bong-soo, we will discuss about the mediation before industrial action. This is stipulated under the Article 45 of Labor Union and Labor Relations.
Simple Labor Union Act.
Labor Union Act.
Yeah.
So, could you define the terminology of this Article 45?
Yeah. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Regarding labor disputes, labor union have a three right of labor, so they have a right to association, independent association, that is we call labor union. Also, labor union has a right to negotiate or they bargain with the employer, so that is a right to collective bargaining. Also, they have a right to take industrial action. So this is a right to collective action. So these are three rights of labor. So regarding this mediation before industrial action, so this is a legal requirement in order to perform strike or some for union to take a strike, they needed to have some legal procedure, that is the mediation before industrial action. Also, they must have a pro and con both out of union members. So they must have a collective majority vote for the strike. So without their majority vote, positive vote, they cannot take a strike. So, but in this legal requirement, before they take a strike, is mediation before industrial action. Yeah.
I see. So we have already discussed about the industrial action in before this video session. So if the industrial action is in place, then it is somewhat disadvantage for the workplace, both for the employer and employee. So if possible, it is favorable to avoid the industrial action. But I understand that the Gangnam Labor Law Firm has a number of experience of mediating between the employer and employee. So could you explain what are the procedure and detail the action before during the mediation?
Yeah. Okay. So labor union after they are established, they must protect their legal right based on collective agreement. So in order to have the written collective agreement, they need to request for collective bargaining with the employer. So labor union, they start to negotiate with the union and employer, and they push more higher or better working condition. So if those negotiation is concluded smoothly based on good result, then it is called the collective agreement. But it is hard to get to the good conclusion. So usually labor union, in order to maximize their bargaining power, they take collective action. We call strike or industrial action. So by law, they must hold the collective action after they going through mediation process. So we call it cooling period. That means before they take a strike, they must go through cooling period. So this is we call mediation process. According to the Article 45 of the Labor Union Act, union or employee must go through collective mediation process before they take collective action. So this is some legal requirement. They must have a mediation before industrial action. Yeah.
I see. So, as a labor attorney, do you have a particularly? I understand that you are currently playing a role as mediator before the industrial action. So, could you give us a small example of how our role was very important for this mediation procedure?
Yeah. So when to have their legal right to go on strike, they must go through a mediation process before industrial action. So how they take mediation? So they apply for mediation to regional labor commission. So labor commission immediately they start to make some mediation committee. So mediation committee should have 3 members. So each one member represent each side, the remaining one member represent public side. So they are like mediators. So they suggest some their proposal that after they review each party's claim, then those request is accepted, then it is like a collective agreement. But either party reject what they suggest, then usually this mediation is not solved, or it is kind of fail. Then union they can have a legal right to take a strike openly, because they already gone through such a mediation process. So this is how we are representing our client in the mediation committee in the labor commission. Yeah,
I see. So rather than avoiding the industrial action, do you think, because the labor union they have the legitimate right to go into industrial action, so rather than going through the mediation, do you believe that they prefer to go into the industrial action? Even they can settle the dispute during the mediation.
So yeah, I think when either union take a strike, it affect very negatively to the company. So also union they suffer from no pay during the industrial action period. So it affect both parties very severely. So through collective mediation process, we like to suggest some acceptable some condition, so they can accept it. Then we call it collective agreement made between union and the employer. So I think this mediation process is very important. This is the best way to solve the solution. People they have a very suffering time like a strike. Yeah.
I see. Thank you very much for your comment.
Okay, thank you for watching. Bye bye.